Okay, so basically, when we talk about international law, this is the law that regulates relations amongst states. So this means that the primary subjects of international law will be states as opposed to individuals. And international law is an increasingly important branch of law. And the reason why it is increasingly important is because of the evolution that has taken place around the world, whereby I would say the world has become so dynamic, and to be up to speed with the dynamism that is being experienced, it has become inevitable for states to be able to deal one with the other. So in that regard, it gives rise to the need for certain guidelines to be put in place as to how these states are supposed to interact with each other. And of course, where you have more than one entity, of course, we expect to find disputes, for example. So the question is, how will those disputes be resolved? If these states decide maybe to enter an agreement in order to achieve something, the question also is, how do they enter that agreement, and how will they perform that agreement up to its implementation? So basically, international law gives us the basis upon which state parties can act together, upon which state parties can seek recourse in case of any challenges in terms of their international relations. And these interactions are very common, and we can see them amongst state entities and also between individuals. But for the purposes of this course that we're looking at, it's public international law, so we'll only stick to public international law. Private international law will be dealt with later, I think in your fourth year. We'll be talking about the conflict of laws. So basically, public international law is the body of rules that regulates relations between states. So that is the simplest definition that I can give of public international law. Now, we need to appreciate the nature of public international law because there are several arguments which have actually been raised to say this is not true law. This is not law that is as effective as our own national laws. So I will briefly take you to our national legal system. For example, when we talk about the Zambian legal system, you will realize that in the Zambian legal system, we have, for example, our sources of law, which we refer to, talk about the Constitution, talk about acts of parliament, talk about delegated legislation, we'll talk about judicial precedent, we'll talk about common law and equity, customary law. So these are well-defined sources of law that we refer to here in Zambia. And when it comes to perhaps implementation of these laws, we have a number of bodies that are involved. We have the police force. We also have other administrative organs that we can refer to. We can, for example, look at the Human Rights Commission. We can look at the Anti-Corruption Commission. We can look at the Drug Enforcement Commission. We can look at the National Prosecution Authority. They are well defined, and we can point at them to say these are bodies that are involved in the administration of justice. When it comes to resolution of disputes, we do have the courts in place. We look at the judiciary in short, and there are different mechanisms that they implement in terms of dispute resolution. Thereafter, if a person has been found wanting, within Zambia, we can be able to point to the correctional facilities or any other remedy that can be sought from the courts of law, and how the end result of a decision is actually made to be a reality. It is definite when it comes to our national legal system. But at the international law level, to begin with, let's look at the sources of law. There are certain sources of law. I'll just give an example for now, like general principles of law recognized by civilized nations. How do we justify that as a source of law? We can ask ourselves to say, as a country, like as Zambia, did we really contribute to maybe the establishment of its sources? But we are a member of the international community. Secondly, how well do we identify ourselves with the sources of international law? Apart from that, let us look at the administrative aspect of international law. Who are the administrators? Do we have an international police force? And which courts are there where we are assured of impartiality? And once a decision has been made, maybe a judgment has been passed, who actually ensures that this judgment is enforced? So if you make a comparison between our national legal system and international law, you realize that, of course, the international regime may appear to be a bit porous, and which is true. There are a number of challenges that are experienced on the international plane in as far as implementing international law is concerned. But however, what you need to understand is that international law is a workable branch of law. International law can be effective for as long as there is cooperation between the states. Because in this particular situation, we are not talking about individuals who are parties to an agreement like we have in contract. We are talking about states which are parties to international law. And the other thing is that each state has its own legal system. So there's this aspect of international law which we need to appreciate, that each state is sovereign, therefore it has its own laws. But we need to find a point at which all members of the international community have to agree in order to make international law work. So some of the things that I've raised, for example, do we have an international police force? Which institution is in charge of making laws at international law level? And are these laws that everyone else is comfortable with? And when it comes to decision making, which body will make decision? Which body will hear issues at international law level? When a judgment has been passed, how will it be enforced? So these are some of the arguments that have actually been raised to say that international law is not true law, but perhaps it is just a set of morals. And it's more like it operates at the mercy of the state parties, because if the state parties do not wish to follow a rule of international law, really, even if there could be sanctions or any other remedies that have been imposed at international law level, you can't really force a state to do something if it does not want to. I will give an example of Zimbabwe. There's a time when Zimbabwe was faced with sanctions, but we did not see Zimbabwe bend. Up to now, we have not seen Zimbabwe bend up to the international community in order for them to be integrated back into their normal operations with the international community. Therefore, that happens to be a bit of a weakness and the challenge of international law. But however, it does not underestimate the successes, I would say, that international law has actually scored. As much as there could be weaknesses, I think almost everything has weaknesses, but international law has scored a number of successes, which we need to acknowledge. Any question up to that point? We're still looking at the introductory part of international law. Are there any questions? Any questions? All right, if there are no questions, then we'll proceed. There are two main theories in as far as international law is concerned. We have the natural law theory and the positivist theory. The main distinction between the two theories is that, according to natural law, naturalists believe that a law cannot be considered to be a proper law unless it has some moral content. So a law cannot be considered to be a proper law unless it has some moral content in it. So they believe that in order for you to obey the law, this law must be a good law. But the positivists have a different view to that effect, where they believe that a law is a law whether it is of moral value or not. That does not really matter. So for them, a law is a law as long as the proper procedure was followed in enacting that particular law. So this is the main distinction between theories as to the basis of international law. So what is the relevance of the distinction between these theories? The relevance is that amongst the members of the international community, some might believe in the natural law theory, some might believe in the positivist theory. An example is, for example, in Zambia, Zambia is a Christian nation. And you will realize that most of the laws that are passed are laws which have a moral content. Therefore, we say that we observe the naturalistic theory of law. But positivist theories, for example, we have secular nations such as South Africa, where even homosexuality is allowed. We have nations such as Australia. So we will find differences in terms of theories that are actually observed by different members of the international community. And this could actually be a source of conflict between different state parties. So that is the theoristic approach when it comes to international law. So I will move on to Unit 2, where we'll look at the sources of international law. It is very important each time you're dealing with any branch of law to look at the sources of international law, or rather the sources of that particular branch of law. The reason why it is important is because the sources give us a basis, the general principles, the basis of the general rules that are observed in that particular branch of law. And the sources are a reference point which will actually help us in case of any uncertainty. So the sources of international law are found in Article 38 of the Statute of the International Court of Justice. That is the statute of the ICJ. And under this article, the court is to apply international conventions, whether general or particular.
Just repeat the article again.
Article 38. Article 38 of the Statute of the International Court of Justice. Article 38 of the Statute of the International
Has
Court
been noted. Thank you.
of Justice. And under this article, the court is to apply international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. International custom as evidence of a general practice accepted as law. General principles of law recognized by civilized nations, subject to the provisions of Article 59 of the Statute of the ICJ, judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. So these are the sources of international law. So we're going to look at them individually, starting with international conventions. When you look at international conventions are a formal source of international law, and they form a very, very important source of international law. A convention, which may otherwise be referred to as a treaty, is basically a written document which contains several provisions relating to the content that has been assented to by the state parties. So an international convention exists in such a manner that, let's say, for example, countries that are maybe producers of copper, such as Zambia, decide to come up with an agreement through which they can work together as copper producing countries and see how they can improve their economies, may come together and put down a number of clauses. They'll draft a number of clauses and provisions, which they themselves will agree on as to how they wish those provisions to regulate them. And once that is done, each one will of course append their signature through a representative, and eventually a roadmap will be given as to how whatever has been agreed on will be implemented in each member state. So that written agreement that we're talking about is what we refer to as an international convention or a treaty. So this forms a very direct source of law. Why? Because it is emerging from the state parties themselves. It will be different from these other sources of law that we'll be looking at, because this one is actually current, because treaties can take various forms. They could be bilateral, they could be multilateral, they could be entered into between two states and so on, as and when need arises. And apart from treaties, the other source of law is international custom. So a custom is basically a practice that is acceptable. So there are certain customs which are widely accepted by states from around the world. A custom is a usual way of doing things. It is a value that is observed by a particular community. So a custom forms a very important source of law, in that in certain situations, we don't need to ask anyone around to say what should happen in this situation, but we'll say that as per custom, it is expected that such a thing must be done. But what we need to realize here is that we are talking of international law. Therefore, it will override our individual customs that we might have, for example, as Zambia, where we have our traditional customs. We're not talking about those customs which we observe as individual countries, but we are talking about customs which will be acceptable by the international community. Therefore, it will require a bit of compromise in order to ensure that there is uniformity in the manner in which this custom is being observed. And to that effect, you must be aware of the fact that a custom has two main elements: the material element and the psychological element. So when we talk about the material element, the material element consists of state practice, where a state actually does the actual thing or indulges in a particular mode of conduct that is expected of them. But we need also to have the psychological compulsion that will lead us to acting in a certain way. That is known as opinio juris. So for a custom to exist, there are two elements that are supposed to be present: the material element and the psychological element. So the material element is state practice. The psychological element is the opinio juris, which actually compels states to conduct themselves in a certain manner. And talking about custom, like I said, we can have customs at different levels. We could have regional customs and universal customs. But what you need to remember above all is that a universal custom will override a regional custom as per tradition. So regional customs are customs that can be observed maybe within a certain area, within a particular region, maybe of Africa. And for example, European Union, as a region of European countries, they have certain customs. Universal custom can be custom that is observed by maybe members of the United Nations, which is the most universal organization. So obviously, we expect that if there's a conflict between customs of the EU and the United Nations, then the universal custom will take precedence. So that is custom as a source of law. From custom, we look at general principles of law recognized by civilized nations. This happens to be a controversial source of law. Just from the title, general principles of law recognized by civilized nations. What is a civilized nation? Which nations, for example, are considered to be civilized and whose practice we can follow? So perhaps a civilized nation is a nation which I would say is exemplary in the manner in which it conducts its affairs. It will be exemplary in terms of its legal system. It will be exemplary in so many other respects. We have obvious examples such as the United States of America, we have Britain, we have certain big names which, of course, we cannot dispute that they may be referred to as civilized nations. However, what about the rest of us as the international community? Are we satisfied that those general principles of law suffice to be accepted by us to say we can follow them by virtue of the fact that they're observed by civilized nations? So, unfortunately, at international law level, general principles of law recognized by civilized nations are an important source of law. And I would say it's more like these countries are more like role models that we do follow and try to emulate because of it, the stability that they have exemplified in terms of the manner in which they conduct their affairs as countries. Apart from the general principles of law recognized by civilized nations, we also have judicial decisions. These are judicial decisions passed by the International Court of Justice, the ICJ. The ICJ can pass binding decisions. The ICJ can pass merely advisory opinions. But whatever the ICJ restates do form a basis of international law. They set the precedent as any other court does. And then we have writings of eminent jurists. These are textbooks. So we have certain writers who have assumed a role of being voices in as far as authoritative commentaries are concerned. Textbooks can be cited in court as a source of law, but it depends on the standing of a particular writer. It's not everyone. Of course, interestingly, I've noted that some people when writing assignments, they'll quote maybe Dr. Ngando's module and so on. Well, those are not authoritative enough. But a time comes when a person, or rather textbooks, will be considered to be authoritative, depending on the prominence of the writer. As you can see, we're saying writings of eminent jurists. So those are textbooks. And apart from textbooks, we have other possible sources of international law. So we have other possible sources of international law, such as UN resolutions. What you need to know is that, like I say, the United Nations is the most universal organization that we have. It does pass a number of decisions in form of resolutions, declarations, even decisions themselves. They do form sources of international law. And we also have jus cogens, which is another source of international law. And this is a general international law, a norm of general international law, and from which no derogation can be made. So those are the main sources of international law. I started by talking about treaties. And from treaties, we looked at general principles of law recognized by civilized nations. We've looked at international custom, judicial decisions, scholarly writings, UN resolutions, and jus cogens. Are there questions? Any questions on the sources of international law? Any questions?
Senior Counsel, I have a question.
Yes, you can go ahead.
Okay, so in international law, I've come to learn that issues are dealt by the International Court of Justice. So let's say a situation where two states are conflicting, for example, Zambia and South Africa, and they all belong to international where this court has got authority. Now, Zambia is not satisfied by the decision made. How is there an appeal to it? How is it done? How does it work?
To begin with, when you look at resolution of international law disputes, state parties are not encouraged to go directly to the court. The primary method of resolving disputes is by pacific means. When you look at the United Nations Charter, it counsels all states to resolve disputes through out-of-court methods. Talk about arbitration, we talk about mediation, negotiation, good offices, reconciliation, and so on. So therefore, if Zambia has a dispute with South Africa, the first thing must not even to think of going to the International Court of Justice. We are supposed to use those specific means. But however, in extreme circumstances where the two states fail to resolve, then that's when you resort to the ICJ. And unfortunately, that will be the highest authority. And once a decision is passed, then we'll live with it whether we're happy or not. So the bottom line is, first of all, we start with those specific means. Why? Because when you look at the number of states around the world, I don't know if we have 152 states from around the world or so. The fact is, the number will remain the same. So it is important that we try to maintain good relations with each and every state. So ADR is known to be a good preserve of relations between states. Even where a dispute is, you amicably find a solution. The challenge with going with the traditional litigation is that in most cases, one party might be aggrieved by maybe the judgment that was passed, and as a result, it destabilizes the relationship. But the point is, through it all, let's look at Zambia. Zambia is a landlocked country. So if Zambia is at loggerheads, for example, with Tanzania, it will make us to be in a bit of an awkward situation, because we will no longer be able to ship things through their costs. So what will happen if Zambia does not have access to their ports? How then are we going to be ferrying some of our goods? So it is very important that you try to maintain good relations. Sorry, I just have a slight network problem. So like I was saying it is important that Zambia, not only Zambia, but any other country, maintains good relations with other members of the international community, because we need each other. It does not matter how powerful a nation can be. It does not matter maybe how economically advanced they are, but we all need each other in the international community. And therefore, it matters how we deal with each other as members of the international community. So the primary way of resolving disputes is using out-of-court methods, unless maybe it goes to extreme cases, then you can make recourse to the courts. Any other questions? Any other questions? Are there any other questions? So we're going to look at international law and municipal law. International law and municipal law. So this part basically refers to the reception of international law in national legal systems. So the question is, how do states around the world apply international law in their national legal systems? So This is a very important aspect at international law level because it gives us an idea as to whether international law will work or not. Because if states are not willing to apply rules of international law in the national legal systems, then international law remains a mockery. So therefore, international law has principles that are quite flexible. International law has principles that have been stretched out to try and accommodate as many states as possible. And having said that, we have two theories as to the reception of international law in national legal systems. We have the dualistic approach. When we talk about the dualistic approach is basically the approach where if a state is upholding it, it means that international law does not have a direct effect on its legal system. It means that some other act must be performed in order for international law to be implemented. So an example of a dualistic country is actually Zambia. We can be signatories to a number of conventions, but those conventions will not have a direct effect on our law unless those conventions are activated by way of domestication. So meaning an act is supposed to be passed to domesticate that particular international law. So we call such states dualistic states. And we also have monistic states. For monistic states, once a law is passed, automatically that law becomes part of the national laws of the country concerned. So meaning international law and national laws will be treated to be one. So that is under the monistic theory. And the other thing that we need to note under this theory is, or rather under these theories, is that states can take different approaches when it comes to observing of custom and also observing of treaties. I just want to read from your module on page 16, where it says, on the international scene, international law is undoubtedly supreme, as is borne out by both arbitral and judicial decisions and international conventions. In the Alabama claims arbitration, the arbitration tribunal concluded that neither municipal legislative provisions nor the absence of them will be pleaded as a defense for non-compliance with international obligations. The Permanent Court of International Justice, in the advisory opinion in the exchange of Greek and Turkish population case, held that a state which has extracted valid international obligations is bound to make in its legislation such modifications as may be necessary to ensure the fulfillment of the obligation undertaken. Similarly, Article 27 of the Vienna Convention on the Law of Treaties stipulates that a party may not invoke the provisions of internal law as justification for its failure to perform a treaty obligation, nor may a state be bound by a treaty that has been expressed in a violation of a provision of its internal law regarding competence to conclude treaties as invalidating its consent unless that violation was manifest. In short, a state cannot seek to evade fulfilling an international obligation because of either the presence or absence of an internal legislative provision. What this paragraph is simply saying is that there should be no excuse to disobey international law. So the primary rule is that all states must at all costs try to follow the rules of international law. But what you need to know is that at this point, we can ask ourselves a question to say, what if the rule of international law conflicts with our national laws? A very good example that I'll give is from our national legal system, where we are saying there's no homosexuality in Zambia. But you need to know that the United Nations does recognize homosexuality. Therefore, are we bound as Zambia to follow that or not? So there's that aspect of state sovereignty, which is still respected at international law level. You may not be forced to stretch beyond what you cannot. But all states are encouraged as much as possible to try and follow the rules of international law. Why is it so? It is because it is only then that international law will be a reality. Because if each one of us is expected to uphold our national legal system, then it becomes a challenge. But what you need to know is that despite this emphasis, we still maintain a certain level of integrity as states, of independence as states. And having said that, we're going to look at an example of how the United Kingdom and the United States of America deal with international law in their municipal legal system. So the practice of the United Kingdom and the United States is the same. When it comes to international customary law, they have the monistic approach, meaning every rule of international custom has a direct effect on the national legal system of the United States and also of the United Kingdom. But when it comes to treaties, what will happen is that each of these countries is supposed to domesticate a particular laws contained in treaties. They have no direct effect before they can become part of their legal systems. And for the Zambian practice, like I've already mentioned, Zambia has to domesticate. So it has to pass an enabling act in order for that law to be domesticated and become part of the Zambian legal system. And so far, Zambia has ratified so many treaties, but very few have been domesticated. So meaning sometimes ratification alone is not enough because the law will remain merely persuasive and not binding. And we see Zambia having ratified a lot of treaties, and I think that is labor law. So basically, that's what you need to know when it comes to international law and municipal law. Are there any questions before we move on to subjects of international law? Any questions? Are there any questions?
I think we can move. Simple answer. No question.
All right. We'll go to subjects of international law. What do you understand from the word subject of international law? Who do you think is the subject of international law?
For my opinion, it's any country or state that is a member of the international community.
The subject, okay. Anyone with a different answer?
I think my opinion is for those open or amenable to international laws.
Okay. Any other definitions of a subject of international law?
If the law applies to international states. In other words, like Zambia and Zimbabwe.
Also,
The law
you're
applies
saying,
to the-
so you're saying a subject is a law applied.
No, international law.
Okay.
Or I answered something else.
Any other answers? Anyone else wants to give it a try before I come in? All right. A subject of international law is an entity. We'll call them, I think I'll use the word entity, which exercises international rights and also has obligations and can actually exercise so many functions on the international plane. So that is a subject of international law. So this refers to international personality, so to say. It refers to international personality of an entity. It can even be an individual in limited circumstances, where this individual has international rights and obligations exercisable on the international plane and can even espouse a claim on the international plane. That is what a subject of international law is. So what you need to know is that since we are dealing with international law, the primary subject of international law is a state. From the beginning, I mentioned to say states are the primary subjects of international law. Now, since states are the primary subjects of international law, we need to appreciate what a state needs to have in order for it to be recognized as a subject. Is it just all states that are considered to be subjects of international law? Or there's a certain specific character that a state must have in order for it to be considered to be a subject of law? What exactly are we talking about? So therefore, the elements that a state must possess in order for it to be considered to be a subject of international law are contained on page 21. And you need to be able to explain what each element entails. When we say a permanent population, what do we mean when we say permanent population? When we say a defined territory, what do we mean? A government, capacity to enter into relations with others, and so on. So I will start with a permanent population. What is a population? A population, of course, is referring to a group of individuals, of human beings. So meaning we need to have human beings present in this particular place that we're talking about. And the number is not given as to what number must be reached for us to refer to as a permanent population. And this permanent population, it's not necessary that it should be a permanent population of the indigenous people. For example, it's not necessary that if this population has settled in Zambia, then it should be a population of Zambians. They can even be Indian. But the most important thing is that they need to have an intention to permanently remain here. They must not be tourists. They must not be nomads. They must not be people who are just here for a while and later on migrate to another place. So they must not be immigrants, but they must be people who are permanently settled here in Zambia. Then we'll refer to it as a population. No need for them to be of the indigenous, maybe race. And the other thing about the permanent population is that these people could have come from another place, but they have decided to settle here. That is fine. The other important thing is a defined territory. A defined territory is a space which a particular place occupies. Remember, we are talking about characteristics of statehood. So these are the characteristics which help us to determine whether a particular entity is a state or not. So therefore, there has to be a defined territory. And a defined territory is a space, the landmass, which a particular entity occupies. Zambia is measured in certain square kilometers. And when we talk about this territory, the territory includes the landmass. The territory will include the airspace. The territory will include the waters below, minerals and everything. All those are included as the territory. I've deliberately mentioned this because later on we'll look at maybe the law of the sea. We'll look at the laws which regulate the airspace. So meaning there's more to a territory than just this landmass that we are saying. So we need to be able to refer to this entity to say this entity is situated on this particular space measuring so many square kilometers, because up to a certain point, Zambia has borders, I think on all four corners. It will have borders in the south, in the north, in the west, and in the east. So that land, which is that area which is now left to us as Zambia, is the defined territory of Zambia. And at international law level, it is very important for us to know where Zambia ends, because once you cross that borderline into the following territory, meaning we perhaps need to apply different principles in as far as jurisdiction is concerned. So it is important that we're able to define this particular space which a particular entity occupies for us to refer to it as a country. If you remember Scramble for Africa, these Europeans were actually fighting for land here in Africa. So they demarcated each place and they perhaps named countries this and that. So that defined territory is what is very important for the purposes of certainty in international law. And I've already talked about population to say once a territory is defined, it needs to also have inhabitants. Apart from that, wherever human beings are, leadership is always important. When you are identified as an entity, the question is, how are you running things? How are things moving in that particular place? You cannot tell me that perhaps 3,000 people settle in a place and they are all doing things the same way. No, we need what is known as leadership. And this is what we're referring to as a government. A government, or let's say issues to do with politics, just talk about which group influences the other in making decisions. All of us cannot uniformly be acting on behalf of this territory at the same time. So we need a government. And once this government is established, a lot of other things will be looked at. Has it got effective control? Is it able to command respect amongst the people? Is it keeping things moving in that territory or not? And because there's established leadership, we expect that this state will be able to enter into relations with another state or with other states. So therefore, these are the four characteristics of a state. One, there must be a defined territory. Secondly, a permanent population. Thirdly, a government. The fourth one is this entity must have capacity to enter into international relations. So when you ask the question to say, what are the elements that the state must have in order for it to be recognized as a state? Those are the four elements. Are there any questions before we go to international organizations as subjects of international law? Well, if there are no questions, I will move on. I mentioned to you that the primary subjects of international law are states. And when we're looking at the sources of international law, I explained that one of the most formal and reliable sources of international law is treaties. We have treaties, it's a treaty. And what you need to understand is that a treaty forms the basis for so many things. For example, if, from the example that I gave, if Zambia wants to partner with other oil producing countries, so Zambia is partnering with other oil producing countries, what will happen is that there has to be a treaty basis before anything else is done. So now, this treaty would have formed what is known as an international organization, isn't it? For Zambia to team up with other, now, just get what I'm saying here. We defined international law to say it is the law that regulates relations between states. And we are saying the primary subjects of international law are states. Why? Because states have direct rights and responsibilities at international law. That is clear. But now, a few countries from the international community decide to enter into a treaty. And they say, we are copper producing countries. Can we enter a treaty? They sign that treaty and they have the terms of reference. Now, we'll refer to that relationship between them as an international organization. So this simply means that because of such activities, a new subject of international law was birthed, known as an international organization. Because there are times when it is not all states which will be involved in the activities of the international community, but it's only a few which will be involved. Therefore, we cannot involve the entire international community, but now we can start dealing with them in groups, and these groupings are known as international organizations. So the basis of international organizations as subject of international law was established in the reparations for injuries suffered in the service of the United Nations case, where some agents of the United Nations were actually injured whilst they were on duty. Now, international law gave a limitation in terms of how a claim could be made in such circumstances. But what the United Nations decided to do is that it brought all claims under one action, and this was challenged to say no. It was challenged by some parties concerned to say there is no way that the United Nations can bring such a claim because it is not a subject of international law. But when you read the dictum contained in this case, you will realize that several issues were mentioned which likened an international organization to a state, and as such, an international organization was said to be a subject of international law, joining the primary subjects of international law, which are states. So then, the following the elements that an international organization must possess in order for it to be referred to as a subject of international law. The first one is that it must be a permanent association of state members with established objectives and administrative organs. Now, when you look at these characteristics and compare to what I've just mentioned, when
just repeat the element again. Just repeat the element again.
It must be a permanent association of state members with established objectives and administrative organs. It must be a permanent association of state members with established objectives and administrative organs. Just here, for states, we're saying they must have a permanent population. So if international organizations were saying a permanent association of state members, so meaning they do have a population. It's just that this population is made up of the states. with established objectives and administrative organs. Remember that under states, we're talking about a government. Why we're saying objectives and administrative organs is because the question is, what was the purpose of forming this organization? So you see now that the example that I gave to say Zambia joins other countries which produce copper. So meaning the objective is to promote the production of copper and maybe strengthen economies of member states. That is one of the objectives that they'll have. Administrative organs. There's a structure that each organization must have. Just like we have the structure of a state will always have a government. A state will have office of the president, vice president, ministers, and everyone else, even up to cleaners, who ensure that the state is running. Therefore, even an international organization, give us a structure. Will it have a chairperson, vice chairperson? Will it have committee members, and so on? And their functions must be clearly defined. And from that, the next characteristic is that it must possess some power that is distinct from the sovereign power of its state members. I've mentioned this time and again to say the only way international law will work is if members are willing to abide by the rules of international law. Therefore, Zambia must forget about its national legal system if it's a member of the international community and ensure that international law will have precedence over national laws for purposes of uniformity. And the other thing is that the powers of the organization must be exercisable on the international plane. So when you look at these characteristics, and according to the case of reparations for injuries suffered in the case of the United Nations, what happened is that the court considered all the elements of an international organization and concluded that the United Nations did possess all the characteristics of an international organization and thus was considered the subject of international law. I would ask you after this class to take time to look at the reparations for injuries suffered in the service of the United Nations case, because next time I will ask you for the facts, and also I'll give you some other cases that you will look at, which we need to discuss. Plus, if at all you do not do that, I will not force you to, we'll just move on. And we move on to individuals as international persons. The general rule is that an individual is not primarily a subject of international law, but under exceptional circumstances. And when I say exceptional circumstances, I'm talking about circumstances to do with human rights and humanitarian law, under human rights and humanitarian law. For example, if an individual is a victim of human rights violations, they can become a subject of international law in that case, after having exhausted local remedies. And the other thing is that if an individual, for example, has committed a war crime, crimes against humanity, that person will have to be prosecuted. In such limited circumstances, the person becomes a subject of international law. So an example of some of these circumstances where an individual became a subject of international law is the International Tribunal for the Prosecution of Persons Responsible for Serious Violations of International Humanitarian Law committed in the territory of the former Yugoslavia. The International Tribunal for the Prosecution of Persons Responsible for Genocide and other serious violations of international humanitarian law committed in the territory of Rwanda and Rwandan citizens responsible for genocide and other such violations committed in the territory of neighboring states between January 1, 1994 and December 31, 1994. These are examples of tribunals that dealt with crimes against humanity. There are so many other people who have appeared before the International Criminal Court. We have the Kenyan president, Uhuru Kenyatta, who appeared before the International Criminal Court. At that point, he was considered to be a subject of international law. So individuals are subjects of international law, but limited to human rights and humanitarian law issues. And the other thing that I must mention is that this, of course, is also connected to human rights, where the protocol to the Convention on the Elimination of Discrimination Against Women, which entered into force on December 22, 2000, also provides recourse for individual petition. And the right of individual petitions is also provided for in the 1996 International Convention on the Elimination of all forms of racial discrimination. And under the first optional protocol to the International Covenant on Civil and Political Rights, the United Nations Human Rights Committee is competent to receive and consider communications from individuals claiming to be victims of violations of any of these rights set forth in the covenant. And I think under the African Charter also, the African Commission equally hears what are known as complaints from individuals who are victims of human rights violations. So under such circumstances, we'll refer to the individual seeking a remedy from such an organization at that particular point as a subject of international law. And the last subject of international law we have under other legal persons, the Holy See. You have heard of the Vatican. You have heard of the Vatican. It's a very powerful nation so far, headed by the Pope. The Vatican has its own population. The Vatican has its own currency. The Vatican has its own government. The Vatican does act on the international plane. You will realize that there are times when the Zambian president can't even recognize a certain meetings, but the Pope will be invited. So meaning it does exercise a number of functions on the international plane. It's a powerful entity. So the Holy See is another subject of international law. So the international community found it fit to accord a status to the Vatican to be considered as a subject of international law. So therefore, in summary, when we talk about subjects of international law, we have states as the primary subjects of international law. And then we have international organizations. We have individuals under those limited circumstances, and we also have the Holy See. Make sure that you remember the characteristics that each one must possess in order for it to be referred to as a subject of international law. So we are done with the topic. Next time we meet, we'll start from recognition of states and governments. I'll take questions if there are any before I give you the list of cases that you should look at before the next class. Are there any questions?
Senior counsel,
Yes,
I
please.
wanted to find out when you just repeat on the subjects of international, you said states, international organizations, the Holy See, and what? Are they three or there are four?
Oh, individuals and individuals.
So when you say international organizations, do you mean organizations like the UN and others?
Correct. The United Nations, the European Union, SADC, COMESA, African Union. Those are the organizations I'm talking about. Are there any other questions?
The other question is on the Holy See. Why you mentioned of the is it Vatican?
Vatican, yes.
So Yeah, so since it has been given authority of being recognized as a subject of international law, can we consider it to also be a state on its own, or we can't?
It is a state, actually. The
It is a
Vatican,
state.
it
has
has,
met.
yes, it has acquired that status, correct. It's a powerful state.
Clear, madam. Thank you.
All right, any other questions? Are there any other questions?
Just before we move, I wanted to find out the case that you are referring to on the elements of an international organization, the citation.
The reparations of injuries suffered in the service of the United Nations. Reparations for injuries suffered in the service of the United Nations. Let me just get the year. 1949. 1949, ICJ reports at 174. 1949, ICJ reports at 174.
Thank you.
Are there any other questions? Any other questions?
Senior Counsel.
Yes, please.
In situations, in scenarios where a state has two governments, the local might recognize one government, then maybe the international world might recognize another government.
Oh, that one is a topic. I don't know if you can, okay, you can go ahead, ask that question, that's fine.
Well, I think I'll wait for
no, you can ask. You can go ahead, it's fine.
Okay. In such, I wanted now to know, to understand in terms of the characteristics that you gave us for a state to be, yes, among those four. So I was confused on that government, meaning which government is going to be recognized in there. If the locals themselves, they have a government that is elected by them and they recognize that, then you find that maybe, let's say America or the international world recognize maybe a rebel government.
Yes.
I don't know. Can that qualify to be a state? Because I think there's a confusion now of what a government is. I don't know, a functional government or something. I don't know something.
Oh yeah. What is very important, I think, in terms of international relations, matters how other states look at you. So if then the locals recognize this government, the international community recognizes the other, meaning it will become a challenge. For as long as you're not recognized by the international community, you may not be able to benefit much from the international community. So for purposes of you exercising international rights, like we have mentioned, it is important that at that particular point, what you do is you make sure that the government that you are recognizing is the government that the international community is recognizing, because there'll be a conflict. So if the government is not being recognized by the international community, it is very simple. They will cut relations with you. So you remain an island. Unfortunately, I think we've seen states where maybe, for example, yeah, we'll talk about that more. We'll talk about de facto and de jure government. Maybe this government came into power by a coup and so on. And most states feel they don't want to deal with this because they came through unconstitutional means and so on. That will have an impact in the manner in which you relate to the international community. And once you are not recognized, meaning you cannot take part in any international activity whatsoever. So you will remain sort of disconnected from the rest of the world. That is where the problem is.
Okay, thank you.
Any other questions? Okay, if there are no other questions, then just take note of these cases. There's the North Sea, I think, let me type them to be faster. So as I'm typing, you'll be able to see them. Okay, so I think for now, you have these cases 1, 2, 3, 4, 5 plus the reparations case. Kindly look at them in the next session. Let me see. The next session will be tomorrow. Now this is the one which is clashing with my other class. So supposed to be 8 to 10, isn't it? Oh, no. Tomorrow it's 13 to 15. It's fine. So we'll meet tomorrow at 13 to 15. It's okay. And then we also need to make arrangements for that human rights class which was lost. Well, that's not a problem. Let's have our first class first, then we'll be able to discuss. So I think we'll end here. It's 10 hours. I'm sure another class has been assigned to use the same login details as these ones we're using.